Namaskar, welcome to my channel Journey of Constitution of India. At 9 pm on 29th June 2020, the Government of India issued a press release and which spread like a wildfire. Some were shocked, some were expecting this kind of thing. By an interim order, the Government of India banned immediately with immediate effect the 59 Chinese mobile apps. Why this drastic step was taken? Let us see by the tweet of Minister of Electronic and Information Technology, Mr. Ravi Shankar Prasad. He wrote the tweet: for safety, security, defense, sovereignty, integrity of India and to protect the data and privacy of people of India, the Government of India has banned 59 apps, mobile apps. The government took this unprecedented steps and important step for securing the interest of nation and protecting the privacy of data of 130 crore Indians. Mr. Nikhil Gandhi, country head of TikTok, one of the app which was banned, in his tweet said that his company will comply and see the legality of the order and take the legal steps. Then the question comes in the mind that what is the legal sanctity of this order? What next will follow? Whether it is a breach of fundamental right of freedom to speech and expression? What are the legal remedies available to the aggrieved companies? And so on. So we will discuss all these questions one by one in the coming video. Friends, if you have not subscribed my channel, please subscribe to my channel so that my video can reach to you at the time of upload. Now you are watching part 3 of article 19, right of freedom to speech and expression, and the name of this video is Chinese app ban, national interest and legality of ban. Normal schedule for uploading my video of this constitutional series is 8 pm on Saturday, but seeing the urgency of this topic, I am uploading it 2 days prior to schedule. The first question: under what provision this interim order has been passed by the government? This interim order is passed under section 69A of the Information Technology Act.2000 by the competent authority. The procedural formalities for exercising the blocking power are prescribed in the Information Technology Procedure and Safeguards for Blocking for Access of Information by Public Rules 2009. As per Rule 5 of these rules, 2009 rules, a designated officer has the power to block public access to online information, but this power can be exercised only upon a request either from a nodal officer or the court of law, the competent court. Rule 7 requires a committee to examine the blocking request from the nodal officer. Rule 8 requires the designated officer to serve a notice upon the intermediary against whom the request has been made to file a reply or any clarification. Then the question comes: on what ground this ban is imposed and under which provision and where it is provided? Ban is imposed in view of the emergent nature of threats on the basis of information available with the government. They are these companies are engaged in the activities which is prejudicial to the sovereignty and integrity of India, defense of India, security of state and the public order. Section 69A of the Information Technology Act provides these grounds there. Secondly, the Computer Emergency Response Team, which is in short known as CERT, received several complaints and representations from the various quarters qua the security of the data which are collected by these apps in India. Now, after this interim order, what is the next step? The next step will be that the government will issue a show cause notice or a letter to the companies on the basis of the principle of natural justice, audi alteram partem. And after issuing this so-called notice letter by the government agency, where all allegations will be enunciated in very specific terms against the companies, that what kind of violations they are indulging in, and then the companies will be given a fair opportunity to explain the allegations in those letters. After hearing the case of the companies, a detailed speaking order will be passed by the competent authority of the concerned department, and that order will be the final order, and that will replace the interim order. The basic defense of these companies, these aggrieved companies owing apps, can be deciphered from the statement of the Chinese embassy spokesperson, Mr. Ji Rong. He gave the following reasons. First, the Indian government step is selective and discriminatory in nature and on ambiguous and far-fetched grounds. Second, it is against the fair and transparent procedural requirements and in violation of the WTO rules. Third, it also goes against the general trend of international trades and e-commerce. Fourth, it is not fair to consumer interest and market competition in India. Now, whether these reasonable restrictions imposed on the fundamental right to freedom of speech and expression will stand the scrutiny of law when the opposite party will go to the court. Friends, under Article 19 Clause 2 of the Indian Constitution, reasonable restrictions can be imposed on the grounds of sovereignty and integrity of India, defense of India, security and the security of state and the public order. This content sharing platform TikTok is popular medium of speech and expression, so the restrictions imposed must be a proportional restrictions, reasonable restrictions having direct connections with the object to be achieved. Here the two objects are that is the ground like security of nation as well as the security of data. Let me remind you a case, Dwarka Prasad versus State of UP 1954 SCR 803. Wherein the Supreme Court in categorical terms held that the restrictions must not be greater than the mischief to be prevented. The second important case, which is very recent and the judgment was pronounced on 10th of January 2020, is Anuradha Bhasin versus Union of India, in which the Supreme Court held that as per proportionality standard, any restrictions on fundamental rights of the individuals must be necessary to achieve the legitimate aim, that too if there is no alternative available. So here the data privacy and protection is the aim. Then what other step can be taken instead of banning to protect the data? So this the government will have to explain at the time when the judicially it will be scrutinized. The most important aspect of this entire issue is that the companies whose apps are banned are originating from China, and China itself has a very strict administrative rules and regulations which govern the companies from their land. And one of these are Article 7 and Article 14 of the China's 2017 National Intelligence Law, which requires all citizens and corporations to cooperate with Chinese national intelligence gathering efforts and maintain secrecy about them. So the apprehension of the Indian government is very plausible and timely, because in the present standoff in border and the adverse steps taken by the Chinese government on the border and the death of our 20 soldiers, these are the providing ample grounds for initiating this process. Another important point here is the right to privacy, which is taken as a fundamental right in India, and by a constitution bench judgment in 2018, the judgment is Justice Puttuswamy versus Union of India, wherein the right to privacy is recognized as a fundamental right. So the government has to take every possible step to protect the data of 130 crore Indians. India has one more valid argument. China has been ahead of every country in setting the internal ground rules by banning many international social media apps in their own country, and thereby, and by this process, they have adopted ring fencing their digital ecosystem, where the outside companies are not allowed to provide the platform of data of this kind of apps. The other important point is the data collected by these Chinese firms and their server are based in China. So at this point of time, either the only other step that government can take in India, that they will ask the companies to keep their data and their server in India if they are allowed. The questions of discrimination which is raised by the Chinese company is that there are hundreds of apps being used in India and they are from the different countries. Why this 59 have been chosen? This ground and the defense taken by these companies will be justified on the grounds of facts and particularly the complaints received by the competent authorities and agencies from the various sources and the representations received by the companies. So in this scenario, we can conclude our today's discussion that the issue involved herein are not only legal but also economic, related to international trade, and political, related to bilateral treaties. So different fora will be approached and these issues will come to the different conclusion in the different fora. But for the first time that India, and which is the second largest internet market, having nearly 130 crore Indian using this internet, India has first time ordered this kind of ban on the foreign apps. After death of 20 Indian soldiers, there is a complete sentiment against China and Chinese government, and so the boycott China has also become a tool to protest. This is also seen as an opportunity for the Indian company to increase their penetration in the market and achieve a level where they can compete with the Chinese product. Chinese smartphone makers command more than 80% of the smartphones market in India. And the TikTok, one of the content sharing app which has been banned here, and this entire episode is known in the name of TikTok ban. So that has 20 crore monthly active users in India, and this is the largest user outside China for many of these apps among the 59. So this is a great opportunity for local alternatives to grab these customers. India is not only country which has adopted this kind of approach by banning the Chinese item. Even in the Europe, for the security reasons, and in the United States in the recent past, some action has been taken to quell this kind of thing. Because one very important aspect is that there is a very lopsided electronic and software market development taking place in the world in last 10 to 15 years. So it requires the corrective measures by the respective government to create a level playing field for their local manufacturers and local producers. The action of government is politically and economically correct. Let us see what kind of battles and what legal battle it starts and how it settles. And we will keep watch on these developments very closely, and we will come to you and we will bring the next video in which we will discuss the various developments in meanwhile it takes place, or any other important aspect it comes to my knowledge. So this is all in the present video. Thank you very much for watching this video. Please subscribe to my channel, and one more special request, that do not forget to send me your comments or your views to improve the contents of the video and the presentation of the video. Thank you very much. Namaskar.